Well, good afternoon and welcome everyone. My name is Ernie Birchmeyer. I manage the Center for Commodity Farm and Industry Relations at Michigan Farm Bureau, and welcome to week 2 of our Ag Labor Series. Over this past year, we've had many discussions with our members about issues that were critical to them, and labor was at the top of the list for many of our members, and we worked cohesively and collaboratively, with a number of our partners to put together an Ag Labor Series to provide you with information that we think will be helpful to you and your farm operations. With us this week is Craig Anderson. Craig will review the Ag Labor Survey that we talked about last week and highlight a few additional areas in that survey. We also have with us Kim Clark from Varnum Law Firm. Kim is going to discuss the I-9 form and compliance issues surrounding the I-9 form. She'll also talk about COVID-19 restrictions and compliance issues relative to COVID-19. We will also have an opportunity for question and answer. The question and answer function is live on the Zoom meeting this afternoon, so be sure to put your questions in the question and answer feature, and we will answer those throughout the meeting when the opportunity presents itself. Without any further ado, again, welcome. We're glad that you're able to join us this afternoon and over lunchtime, and we will get right into our program. First up is Craig Anderson to review the Ag Labor Survey and go into a bit more in depth into the Ag Labor Survey and issues that we discussed last week. Craig, the floor is yours.
Thank you, Ernie. Again, my name is Craig Anderson, and I'm going to be talking about the National Ag Statistics Services Farm Labor Survey. This is a very important tool, as you heard last week from Adam Kantervich. Here's one of the pages out of the Farm Labor Survey report, and I'm going to highlight the field and livestock combined wages. It is important to understand that this page and the balance of the report are used in multiple different federal provisions that are linked to the wages that are paid in agriculture. Michigan is part of the Lake States. And if you take a look at last year's April 12th through 18th document, it indicated that we are at an average of $14.60 an hour. Our current adverse effect wage rate for the H-2A program in Michigan last year was $14.40. Many are suggesting that this report and the activities related to it are really pressing an inflationary structure. So a proper understanding of how the report functions, what the report is asking for, can possibly minimize the inflationary effects of this particular survey. So if you look at this graph, if you look at the right, it indicates a percentage of the average non-farm versus farm activity. You notice that we have had a fairly significant raise, and this corresponds to the use of the Farm Labor Survey in determining the adverse effect wage rate. So these are the areas that are in question as to how and when and why we fill these out. Now, nationally, there are going to be approximately 35,000 farms, excluding California, they do their own, that will be receiving this survey. One of the issues that has come up is that we have had some quite small farms be engaged. NASS is indicating that they are sending these out to farms with over 10,000 gross. So that too is important because we have an awful lot of farms that have relatively small income streams and may have a significantly different wage structure than traditional larger scale operations. It will be sent April and October for particular weeks. And that is very important to understand, that the data that you're reporting is for this part of the form only for the working week in which they are requesting the information. It is not for a month or the year, it is for the people that you have working during that period of time. Now, definitions, as always, are very important in understanding what we're looking at. So when the survey comes out, please recognize that it is workers directly hired by farm operators. So that doesn't include all workers on the farm or working in agriculture. A hired worker is anyone other than an agricultural service worker. We'll touch base a little bit on that as we go through, who is paid at least 1 hour. In many cases, when we reviewed some of the farms' reporting, what we found is that you had operations who were not reporting the high school students who worked for a few hours in that week. And so you have to take a look at everyone that you're paying during that period of time. And a note here is that the all hired worker category includes supervisors and other workers. And that is very important in understanding what we're truly looking at. Let's take a look at field workers. So under the report, we have a definition, and most of us have read that: employees engaged in planting, tending, and harvesting crops, including operation of farm machinery on crop farms. So that is important as well, to understand that it doesn't include all activities in terms of what we would have. Now, the NASA is utilizing or trying to move closer to the standard occupational classification codes, SOCs. With that, please be aware that there is a NASS crosswalk, and we will put information related to the documents that we're talking about in the resources after the program is completed. But let's go to the survey. This is the language that you're actually seeing in terms of the survey that you received. And that's where we've had many folks question how they approach many of the workers that they have. So on the survey, it describes farm workers engaged in manual activities using hand tools. And then it describes duties, and those duties include, for example, applying pesticides. However, if you look at the form and if you look at the data and the instructions, is a pesticide applicator to be entered within the farm worker structure? They're operating a tractor, so is that manually? Is it powered equipment other than a tractor, converted trucks, for example? And is this their primary task, or is their primary task to till the soil, plant, cultivate, or harvest crops? Generally, a pesticide applicator is going to be listed under other workers, and specifically under pesticide handlers and sprayers. So let's move to the livestock category. Remember, both the farm worker and the livestock worker are going to comprise the data point that establishes the adverse effect wage rate. Here, under the report, it identifies employees tending livestock, milking cows, and operating farm machinery on a livestock or poultry operation. So there are several areas that would not include all situations of agricultural production. But let's go back to the survey. So when we look at how it is defined here, it is to attend to live animals. There are many situations on farms that are not in regard to the live animals in terms of production. So look at your specific work and responsibilities to determine whether they are actually engaged with the live animal side of the operation. And then when you look at duties, it does include catching and loading of the animals. However, there are many types of situations that may be excluded. So let's talk about unit catching. In many cases, where you look at unit catching, it is a structure in which you have essentially a third party come on. You either pay the crew maybe time and equipment. You might have a lump sum payment. You might have activities deducted from the buyer who actually does the catching and loading. These are going to be included within agricultural services or contract labor in many cases. Not all cases, but in many cases. So I've talked a little bit about understanding what it is that you are going to put down there. NASS has some specific excluded categories. And the first one is the agricultural services. So fairly straightforward. If you have a tiling operation, clearly that's an agricultural service, but there are many other situations that would fall under the agricultural services structure. The second one is contract labor, paid by a crew leader, contractor, buyer, processor, cooperative, or other person. So for example, if you have an HLC, in other words, a labor contractor who is operating within the H2A program, that is contract labor and would not be included within your reporting. That would be reported in a separate report. Custom work performed as a unit. So we do have a fair amount of sharecropping activities and other types of custom work. Please understand too that there is an exclusion for this. Retail workers, value-added workers. If you're making yogurt on the farm, that is not going to be part of what we're looking at. Likewise, the retail activity, in many cases, some of the office workers, those types of positions would not be within the definition here. And again, remember, look to the identified week. So what are we actually looking at? The wage reporting structure is important to understand as well. So clearly we need to take a look at the codes, go over the codes that are in the report to make sure that you properly identify. The number of workers paid in that week is separate from the total that you might have at any one time during the year. Base wages are an area that has become kind of a question mark as well. It is important to understand that you can have workers that are doing multiple jobs. Most of our operations do that. So take a look at their primary task. So for example, that pesticide applicator may do some harvest activities, may do some other activities, but their primary task is that pesticide application. Where you look at that individual who does more than one task, report each worker only once. Don't split out to multiple different segments. So let's take a look at the base wages. The base wage is that gross wage less any regularly paid bonuses, overtime, or other incentive pay. So in particular, think about that piece rate structure. It's not uncommon for people on piece rate to earn significantly more than the base. In Michigan, our current minimum wage is $9.65. And it is important to understand that if a person didn't make that, you would raise their wage up to that minimum. So that $9.65 for most piece rates would be the base, unless of course you're in the H-2A program where that adverse effect wage rate of $14.40 would be there. And also wages do not include benefits such as housing, transportation, and clothing. Recognize that most of this information you already have, it's just a matter of organizing it. The records requirements and pay stub requirements, for example, if you're unfamiliar with those or unsure, the Barnum Manual has a very good section in terms of determining what are the records required for agricultural production operations and what are the requirements for your pay statements to include as well. So there are a couple of general questions on there. Again, remember, it is the agricultural workers that you're looking at in that week. In the broader sense, it takes a look at the largest number of agricultural workers you may have at a time. So it isn't the total number of I-9s that you might have, but it is the total number that you would have at any one time in terms of your operation. Also, please recognize and answer the question whether or not you have H-2A workers that are operating on your payroll and check the dates or the year requested. So for example, the April request is, did you have any H-2A workers in 2019? That request, of course, was in 2020. So with that, I'll open it up. Put your questions in the question and answer box. Now, one of the challenges that we regularly hear is if I have questions on the form, who do I contact? You should all be receiving a survey letter in advance of the NASS survey arriving, and that does have a contact number. And also recognize NASS will be doing some in-person surveys to make sure that the data is correct. Thank you very much.
Very good. Thank you, Craig, for that update. Very much appreciated. And as Craig indicated, if you have questions, be sure to put them in the question and answer function on the Zoom meeting this afternoon. I see we have a question in there, and our speakers will address those either verbally or they will respond to them with written answers in that question and answer feature. So be sure to check that. We're going to move on and transition to our next speaker, who's going to cover a couple of topics for us. Kim Clark from Barnum Law Firm is with us. Kim and the Varnum Law Firm have been important partners for Michigan Farm Bureau for Great Lakes Ag Labor Services and for us over the years. Kim is known for her expertise in labor-related issues. We're glad that she's able to join us this afternoon to talk about I-9 compliance and the I-9 form. From that, she will transition into COVID-19 restrictions and compliance relative to COVID-19 restrictions. Be sure as she goes through her presentation, if you have questions, to drop them in the box and we'll do our best to get those answered. So Kim, thanks for joining us this afternoon. It's great to have you visiting with our Farm Bureau members across the state. We look forward to the presentation and the information that you have to share.
Thanks, Ernie. Hello, everyone. It's fun to see all the participants' names down the side. Many of you that I saw on the list are already subscribers, but I kind of want to tell you what I'm going to be showing you. So Michigan Farm Bureau came to Varnum 6 or 7 years ago and said, we need to find a way to get information out to farmers and to have one spot where they can go and have all the information at their fingertips and know that it's up to date. So what we have created is our agricultural employment guide. It's a subscription service. So you subscribe annually and you get your username and password. And this is what the opening screen looks like. And so we have all the different topics down the side, and I'm going to show you the information that we have on the 2 topics that I'm going to address. The one thing before I forget, we get news on timing of the survey. Just recently, well, today, National Council of Ag Employers is having their seminars at the same time we're doing this. And my colleague is there, and there was an indication from Department of Labor that they expect the information to be transferred from Department of Ag on February 10th to Department of Labor. And then those wages, those HOA wages that everyone has been waiting on, should come out February 24th. That's always subject to change. That's the latest information as of a couple hours ago. So that's the end of the wage survey information. So my topics today are to cover I-9s. And so we're going to go to the I-9 section of our guide. And as you can see, with all of our sections, we have an overview, which is the summary. It is what you need to know about completing the I-9 process. We then have a resources section where you can link to all of the different resources, and those are some government resources like the I-9. So when you click that button, you'll get the I-9 in English. If you click the I-9 in Spanish, that's what you'll have then populate your screen. This I-9 Central, that's the USCIS information along with the employer handbook. We also have on there an Form I-9 self-audit memo. So this was something that Varnum created and put as a template available to subscribers. And every time you go through your I-9s and you're making corrections, it's good to put in a memo to the file to explain that you did do the audit, the things that you found. These are all sample things that you may have found in your I-9s when you do your review. You leave on the ones that are appropriate, you add additional ones that need to be added, but it documents for yourself that you have completed the audit and the results of that. Each of our sections also have a frequently asked question section, and we add these each year as we do our subscription seminars. We get questions, and we'll get some questions today, I'm sure, and that allows us to then build on the resources that are available to our subscribers, so that if you think somebody must have had this question before, they probably have, and you can look in the frequently asked questions area. So let's go back to the overview part of it. Big picture, if you have employees and they were hired after 1986, that's the match date, then you need to have I-9 for them. And so it also counts if they were employed before 1986, but you incorporated and you became a new employer. So you had a new employer identification number. So that's the big first step with the self-audit, is to take your employee list, go to your I-9 files, and confirm that you have a current I-9 for everyone that's currently employed. You are required to retain the I-9s after an employee terminates. It's 1 year past the date of termination or 3 years past the date of hire, whichever is longer. And there's a retention section in the record keeping right here that talks about that. Often employers will just put in place a 3-year retention so they don't have to worry about how long they were employed before they terminated, and that would cover you under either situation. So we have seen some I-9 audits recently, and particularly in ag. It's been West Michigan for both of them that I have currently, and they've been cooperative so that they've been willing to take, especially during COVID, they've been willing to take electronic copies of the I-9s to review. They've been patient in their responses after they send out determinations. And so we're in a fairly cooperative state right now for our I-9s, but it's always good to go back and make sure you're in a place where you don't need to rely on the cooperation of ICE and that you're in a compliant place. So take your employee list, go through your file. If you don't have I-9s for individuals, complete it now with current dates. You cannot backdate. If you backdate, that's a fraud issue. That's a much bigger problem than just not having the I-9. So at this point, if you find those individuals that you do not have I-9s for, then you go back and complete them. As a general process, you want to complete the I-9 at the time of hire. And there has to be an offer and acceptance of employment. So sometimes employers will get tripped up and they'll do I-9s as part of the application process because you want to know if they were authorized before you even offer them the job. The rules don't let you do it that way. You have to make the offer and acceptance of employment, and then during your orientation period, that's when you would complete the I-9 typically. So the I-9 requires that the employer make a reasonable inquiry, because sometimes I'll hear from, especially ag employers who know the statistics in the industry of unauthorized workers, and sometimes I'll hear from employers, well, I don't think that that's an accurate document, and try to think too much about it or try to shade what they're thinking or assessing. And what the requirement is under the regulation is that you review the documents live with the person in front of you, and you make the assessment both that it's a valid document and it relates to that person. That's your job in the I-9 is reasonable inquiry. And so if the card is the wrong size, if there's misspellings, if there's a different color than you've ever seen, all of those things make it not reasonably valid. And I have had employers who really want to get to the details of how to understand and identify fake documents. And I still cooperate with you if you want to learn that. I sat through with employers where they bring in a whole box full of fake documents that they've collected from individuals over time. And they'll sit down and review those with you if you want to become a document expert. But that's not what the regulation requires. It just requires that you do a reasonable inquiry. In COVID, there were some provisions, if you were not in person, that you could do remote completion of the I-9. And all of those extensions, and it continues to be extended, all of those extensions require that when you do come back in person, that you need to do the live part where you submit the original document with the person in front of you and do that assessment. Most in ag are live in person anyway and are not doing remote work. So probably most of your I-9s were not completed remote during this COVID period. So what I like to do is kind of break it down by section because different sections have different purposes. And so first, when we look at section 1, and I'll pull up the I-9 again, this is the employee section. And so you need to provide instructions, provide the form for the individual to complete themselves. They can have a preparer. There's a section down here for a preparer translator. So if they are not able to understand the form, if they do speak Spanish, we have the Spanish one available. They cannot complete the Spanish. They have to use that as a reference. It's one of those silly rules. You can only use the Spanish one in Puerto Rico. It doesn't really help us here on the mainland, but it can be used for reference. So what your obligation as the employer is to make sure it's complete. The substance of the information is the employee's. So there's no reason that the employer should question whatever information is placed on the document, but solely the employer should make sure that the document is completed. So employee goes through, fills in name and address. This is the magic part for the employee, is deciding which of these 4 factors or 4 categories they want to check. So if you would have an information session from immigration, they would explain to you that number 2 should never be an answer unless you're from Guam or some other islands in the Pacific. And so they would tell you, immigration would tell you, if you see that, then you need to correct that with the employee. There's nothing in the regulations that say that. It's in this section 1 is the employee's information. If you get involved with that, you're taking on that role and you're potentially eliminating an employee because they may not have anything other. That's the box they want to check, not your job. ICE tries to make some things your job. Don't take that up on them. Just make sure that a box is checked. And if number 4 is checked, but both if 3 is checked, then you have to put in, the employee has to put in the number here. If number 4 is checked, then you have to have an expiration date and then information down here. Every time the government creates a new form or modifies the form, they make it more confusing. So we've always had a problem with where the signature should go on the I-9 form. Here, it's kind of buried in the middle, and we get a lot of I-9s when we're reviewing that we'll see the employee sign down here. That is not the correct location. It's up here. This is prepare a translator. The other thing we're seeing on audits is that the employee is not checking one of these boxes. They need to affirmatively check whether they used a prepare a translator or did not. So that's all the employee section. Then when we move to section 2, we're going to have the employer needs to write in the information from section 1. So it's last name, first name, middle initial. And then for the citizenship and immigration status, it's whichever number was checked here, goes into that box. And then the employee is provided the list of acceptable documents, which we have as page 3 here. And they have the option of providing list A or list B and C. So they do not have to provide all 3. If they provide all 3, you as the employer can select, and you might as well select from list A because it's easier to just do 1 completion rather than 2 completions on the columns. And so you would go into your, if they provided a list A, and you would fill in these sections. The reason that there's multiple sections here on list A is because if the individual is on a work visa, you're going to have a passport and their I-94, and so you need multiple boxes for it. But you don't have to fill in multiple boxes. If you get a passport, it's going to be just 1 box that's completed. If you get a permanent residence card, 1 box that's completed. A lot of, again, I've been doing a lot of these audits. We do the self-audit for the employer before we hand them over. I'm seeing a lot of missing issuing authorities and expiration dates, and some portion of this employee section missing. Historically and continuing, we have employers that forget to put in the employee's first date of employment. You can consider that the date of orientation. You can consider that the date of hire. You may consider that the first day of active on the job employment. Since you should be paying for orientation, that in orientation day and first day of employment should be the same date. Bottom line is you have to put in whatever you put in, you should do it consistently. So if you decide that it's going to be the hire date, then do that on all your I-9s so that there's some understanding in connection with the documents and the dates on the documents, which one you're using. For instance, if you're doing date of hire and you don't do orientation for 2 days, if all your I-9s are a day or 2 before the completion of the I-9, then that makes sense to the immigration officer that you're doing it at the time of hire and not at orientation. But if you have inconsistent dates, it raises red flags for the officers to then question whether you're doing it as part of the application process and not, and only for some candidates, and not consistently with the date that you made that offer and the acceptance came in. On the employer section here, you may pre-fill all of this, the title and business name and address, but you do need to originally sign and date. So those 2 boxes need to be original. The rest can all be completed. The section 3 re-verification and rehire section is used if you have an expiration of a permanent residence card or an unemployment or an employment authorization document, or if the employee in section 1 indicates that they have an expiration date. They check for and have an expiration date. Those are the situations where you're going to need to re-verify. You should document those days, calendar them, so that you know that you have to pull the I-9, the employee has to bring in their new documents before the expiration date. That's something we often find in a self-audit as well, is that when we go back, we find that there were documents, permanent resident card or employment authorization cards that expired and we didn't re-verify them. And so we need to do it at the point where we're doing the self-audit. Driver's license expiration does not matter. Social security number doesn't have an expiration, so not an issue there. Permanent residence cards, Employment authorization cards. I tricked myself on this issue. Permanent residence cards do not get re-verified. Those are permanent. The status is permanent. When you rehire someone, you can do that you can use this document for the rehire section within 3 years. And then at that point, when you are pulling up the I-9 for them to restart and restart employment and review the I-9, at that point, all the documents need to be valid. So the permanent resident card, the driver's license, they would need to be at that rehire date valid. And if they're not valid, you need new documents. I want to repeat that because that was a very big difference in what I always advise, and I want to make sure everybody hears me loud and clear. Permanent residence cards do not need to be re-verified. It is employment authorization cards, expirations in Section 1, and work visas. So sorry about that miscommunication there. So then let's go back to what we have in this overview, so that all those things I talked about are laid out here, Section 1, Section 2, the re-verification with the correct information of unemployment authorization document only. Do not re-verify permanent residence cards. So that information's there for you. The record keeping part is what I talked about already. You need to have one for all current employees and terminated employees. If you retain for 3 years, that covers the requirements and the regulation. A little bit more about the audit process and then the results really that will come out of that. So if you have an I-9 audit, you'll send in all of your I-9s. My recommendation is that you review them, do a self-audit, make corrections. How do you make corrections? You have to make corrections so that they're viewed they're visible by the officer. So we're not trying to backdate. We're not trying to make them in whiteout. We are doing it because we want the officer to know that we found this mistake, we made the correction, and we dated it the current date. So I've worked through that a few different times in these last couple of audits, and we're seeing that individuals are just thinking that they need to backdate. They just need to backdate, make it look right. No, you can't backdate. That's one of the biggest problems that immigration finds when they're are going through the audits, and that rises it to a whole nother level of fraud. So just make the corrections and even do them in a different color pen so that they're obviously visible to the officer during review. When they do their review, they're going to come back with a corrections notice. And so hopefully you caught them all. Sometimes I will get a corrections notice that they document all the things that we already corrected. And that's fine. We already corrected them, so we really don't have to do anything else. And sometimes it will just be the format of which they want the correction. So maybe they prefer a different way. There are like a different location for it. If you have multiple corrections on the same I-9, you might see an officer return it with something different highlighted and some direction on how to do that. You could also get what's called a must terminate notice. And those are individuals that you employed that immigration knows who they are and knows that they do not have work authorization. They've been previously deported. There's records in the immigration system that demonstrates that they do not have work authorization. Those individuals, you have no choice. Those individuals you must go to and terminate. The notice of suspect documents is different. They don't know, immigration does not know whether they have work authorization, but they know that the information that was provided by the individual was not available in their system to confirm. So they know that this information doesn't work, but immigration is willing to double check and run through new information that the employee may provide. So the conversation with those employees is different than the must terminate. Terminate is, I'm sorry, I've been advised that you don't have work authorization and I can no longer employ you. For the notice of suspect documents, the conversation is immigration has told us the documents you provided us do not confirm your work authorization. If you have other documents you can provide, we can review those with immigration. Sometimes things have happened over the course of employment where someone's immigration status could have been corrected over that time. And so it is possible that we would have a situation where the notice of suspect documents person actually gets verified in the second round of things. And this is kind of a back and forth. So what we've seen with our recent audits, we're on round 3 with one of my employers. They hire new people. They want to see new people's I-9s and check them. And then they send us, well, 5 out of 9 of those are good, but you still get the notice of suspect documents for the 5. You got to deal with those. We hire more. And so it's kind of a round robin thing. I've had some employers who have been able to stop the round robin by agreeing to sign up for E-Verify. And that has placated immigration into a situation where they believe that going forward, your I-9 information will be verified in their system through that program, the E-Verify program, and then we'll stop the investigation there. There is opportunities for immigration to assess civil and criminal penalties. Those typically are not in a first audit situation. They're usually in a second audit. So if you get audited and you have notice of suspect documents or must terminate notices for several of the individuals, then they're likely to come back. And they usually come back 2 to 3 years later. And at that point, if you still have issues, and it's really not issues that you knew about, again, it's reasonably valid documents, but if you still employ those individuals that they told you cannot employ, and somehow you are still employing them and you're just ignoring the directives, those are when you get into the penalties. And we've had some significant penalties, and they have been, many of you may remember in the Thumb area, there were some dairies that had some trouble with immigration, and just their response to it was that we can't possibly run our operation without these individuals, and it did cost them significant amount of money and criminal prosecution. And so bottom line is, it's not easy for anyone to deal with the work authorization issues, but this is a requirement. This is what we need to do as an employer under the work authorization rules. The good news, potential good news, because I've been doing immigration and ag for almost 25 years now, and we've been waiting for immigration reform. The last immigration reform we had was in the 1980s when I was back on the farm. And we hear from the Biden administration that immigration relief for agricultural workers specifically is a high priority. And it's not an overtime thing, it's an immediate permanent residence is what's being proposed. Now, that's only proposed, and it has to get through Congress, and it will likely take lots of twists and turns and potentially not to get done. But at least we've got some conversation about that, which is, and even on day one, which often we see immigration doesn't get proposed until at least 6 months into an administration. And then before you know it, midterms are there and nothing gets done. So there is some potential here. The thing I want you to know about that is that it is not law yet. And so what we often have happen whenever there's conversations about immigration reform, we get employees who are super excited about the opportunity. They've been struggling all the years, hiding the fact that they've been unauthorized, and they just want to share that information with their employer that they trust. The problem is, as soon as you get information that someone is unauthorized and we don't have the protection of the law yet, you're in the situation of the must terminate letter. You have information that the individual does not have work authorization, and so you must terminate that individual. So how do you hedge that off? A lot of communication, like presumptive communication with your employees, saying, we understand that there's some conversation about immigration reform. You might all be interested in it for a variety of reasons. We're monitoring that right now. It is not a possibility because it is not yet enacted. And so we will monitor this. And if there's an opportunity, we'll continue to share that information as it happens. And hopefully that gives you the opportunity to let your workers know that you're on it. When something's viable, you'll come to them, and that they won't affirmatively raise it with you and put you in the position where you need to terminate. So I had this tab pulled up. This is immigration. So this is the other thing that our guide does, is that it gives you these links directly to the immigration website. This handbook for employers is actually pretty good, and it gets updated over time. And so that you can access right through the guide, and it will take you to that information. On FAQs, I just want to hit one. just so you understand the kind of things that we cover. So when they came out with the new I-9 electronically, we had a lot of questions. Do I have to do it this way? No, paper still works. So you can download the paper version and use it. What I will tell you is that I have seen on the audits that I've done, the ones that are electronically completed tend to be better because it self-checks it for yourself. The problem we have with it sometimes is that it makes you do what immigration wanted you to do on if they check the wrong box. So for instance, they checked an alien authorized to work, which would be a permanent residence card, but they give you instead a passport, a US passport. And so that's not on the drop down. If you go to the electronic I-9 and are trying to complete it, it will indicate that you are not authorized, or you cannot put that in. You can only put in if you are a permanent resident. And section 1, it will give you options of permanent residence card and then all the list B and list C as well, like social security number, driver's license could also work, but would not allow you to put in a US passport. So then you're sitting there with a document that is inconsistent, and you're going to have to then make the choice to get involved in section 1 and take responsibility for section 1 and have them correct section 1, or not completing it online. So it was a larger concern when it first came out, but I think it does put employers into the position of being more actively involved and then taking on more responsibility about the I-9, particularly in section 1 if you do the electronic version. So, okay, I've got a couple questions. An employer hires an individual that presents a permanent residence card as their documentation. A month later, the employer during an I-9 self-audit realizes now the individual's permanent residence card has expired since the time they were hired. Does that employee have to present unexpired to continue employment in this scenario? No, thank you. You've one more time highlighted permanent residence cards do not need to be re-verified if it expires after the time it's completed. So in this question, the permanent residence card expired after completion of the I-9, no need to re-verify. And then you access the website by becoming a subscriber. So the second question was, how do we access the website? We'd be happy to get all of you subscribed. There's information that was scrolling, and we'll make sure that we get promo information out. When you go to our guide, it does have, where you go to subscribe, it does have a preview. So you can take a little look at the different categories and things. It won't give you all the details of the guide, but it gives you the overarching information of all of the different categories that we cover. So, okay, my video is back. It kicked me out of video for a while, but now I'm back. So now let's move to the COVID. So one of the things that I think this year became entirely clear to us was how much this resource could be used to keep people updated. Because as all of you know, information just continued to come out. And we did get a question early on about one of the changes that was highlighted in our advisory. We had an advisory up there that when the regulations came out and IRS said that you cannot get H-2A wages credited under FFCRA. So we had that advisory up. And then when we heard that they reversed, we put up this advisory. And so those are all linked through our guide. And when you're a subscriber, you get those emailed to you as well. So it's not on you to have to go in and double check things. But when you do come here, everything is up to date. So for instance, we had the ability this year to link to our coronavirus task force, because we at Barnum across all industries had a task force developed. So if you would go to the task force, I'm obviously part of the task force. We have all these different areas covered because they were all impacted by COVID. You can get our news publications, and that's where you're going to find the agricultural advisory here. But you get other information as well. So one of the other things that I think is a buzzing question right now within COVID, and I think needs to be answered, is what's going to happen when we get the vaccine? And we have the opportunity when it opens up to the general public or even to the agricultural workers that are prioritized. And the estimates on that, because we coordinate with Michigan Farm Bureau and post their information. So the estimates on that look like they'll begin in May. April or May timeframe is when we think that we're going to be getting vaccines available for agricultural workers. So what do I do as an employer? In either situation, that I think everybody should be vaccinated and I want people to complete that, or I am not going to require it because I don't want to get the vaccine. What do I do as an employer as I'm making those choices? So the thing you need to know is there's no clear law on this yet. There's a lot of conversation about it. We don't really expect that there's going to be a nationwide or even a statewide requirement on it. I think that the approach that we're hearing from most is that to highly encourage it, make it available as low cost as possible, and allow for workers to claim exemptions from a requirement. If you are going to actually require, you need to be careful about religious objections as well as medical condition objections to taking the vaccine. And so if you decide that you think it's critically important to your operation that you have a vaccine requirement, you're going to need to make sure that you process through those exceptions to that. And so this gives you all that information and kind of tees that up. Again, if we have changes to this, I never expected last year we were going to have mandatory testing of migrant workers, and we did. And so it's possible the state could try to order this, the mandatory testing, and or potentially employer paying for the vaccine if there's costs involved and it does not remain free of cost like it is now. So we're going to continue to watch those developments, and we will get that information out to you. This landing page of our resource for agricultural employers gives you, again, the links to the different acts if you want to see the background of it. We were today updating and we're getting that OSHA information on here. So with the executive order that was issued by Biden on the OSHA task force, so that there was a national standard. So one of the things that Biden did is an executive order that said, we've got this patchwork of things throughout the state. We want you, OSHA, to put out guidelines that are consistent for the country. And so that's what they did. And that is right here. It was issued January 29th. So we're 5 days later. We've got our summary up of what you need to know, but we also have the link directly to the information for you to review yourself. So the overview of it, and what we know that we want to deliver the practical information to you upfront. So what's the big picture on this? The big picture is there's no legal obligation. There's nothing that came out in that guidance that we were required to do as an employer to do anything. But here's what it did do. It gave more detailed information. It reminded employers of the general obligation under OSHA to have a safe and healthy workplace. It encouraged employers to establish their COVID plan. I'll talk about that in a minute. It reminds employers of recording and reporting requirements for employees who contract COVID, and really went very detailed, and the contact, more detailed than I think they really needed to do, but they did the detail. And then anonymous process for COVID concerns, and even when somebody's vaccinated, they still have to wear the mask. Those are the things that are coming out of it. So this is kind of put in one place what OSHA thinks is most important for a safe work environment. What will happen with these? I think that all states will kind of be watching those things as they're reviewing their plans and their policies in combination with this to make sure they're hitting all the issues and maybe revise and add some details. There are some states that really just don't have much. It will be interesting to watch the developments to see if over time the Biden administration does make this a legal obligation. At this point, it's not. I think at this point, it's trying to get that information out there. One of the hard things with COVID is that there was so much thrown out that compliance and getting things in place were difficult because there's short supply. So it was masks that we were retaining for our healthcare workers, and then bleach wipes went off the shelf, and also hand sanitizer. So all of those things, when they put things out there, create this frenzy. And I think that's part of the reason it came out with no legal obligation, but more just guidance at this point. But we'll see where that goes. with the COVID preparedness and response plan, our latest update, and that was November, we're working currently on our current version of that. Some states, including Michigan, have now put a sample template together. Whenever we do something on the guide, we try to make a Spanish version because we know that many of our employers need a Spanish version. And so it makes it easier for you as an employer to come on, take our template, customize it. What I will tell you with everything that we have on here, it's only as good as it is. It is better when you customize it. That's what I'm trying to say. I think that, you know, I see so many of my templates out there and really you just put a name on the top, and that's not what I want for you. What I want for you is really to take walk through it with your operation and customize it so it's really meaningful to the operation and to your employees. And so that's what we did with the plan. And again, we're going to continue to revise that. In addition to it being in Spanish, I think what you'll see as you preview my guide is that it is as short of words as possible. I did when I developed this, I met with a group of farmers and I thought I had the words really short, and they proved to me time and time and again how they already jumped to conclusion with the first 3 words. And if I couldn't say it in the first 3 words, they didn't want to hear it. So we try to do that with our templates and our plans too. They're not legalese, they're direct, and they are there to help you. The question that came up on, and I referenced our advisory, the question was actually, how do I get this credit back? Because IRS came out so late that I already filed my 943 and there was no information on that. When there is information on that, there will be an advisory, an email will go out to subscribers and we'll give you that guidance. I doubt that IRS will be able to do anything without, they need to get the information. So it's not, if it's not an amended form, it's going to be some shortened version of a form that will just allow for reporting of those wages in a refund. But government tends not to be able to create special forms very easily. So it probably will end up with an amended form. We just don't have any information on the specifics of that yet from the IRS. So if anyone else has questions, I'm happy to take more questions at this time. I'm going to put up, this is who we are at Varnum. Aside from the partnership that I have with Farm Bureau and the subscription to the guide, we have a full service approach to agriculture. And so we cover all the areas. And I was doing a presentation yesterday, and it's one of those things that I forget to tell people because people know me for the labor and employment and immigration pieces of things. But it's really best if you get your professionals all coordinated, and we're happy to be that source to coordinate it all. But even if you don't use us, you use other service providers. I think one of the disconnects that we find a lot in ag is that you work with an accountant and the accountant doesn't know what the lawyer's doing for you, and bringing all those services together for you, I think really gets a comprehensive plan that makes sense. Thanks, Ernie.
Thanks, Kim. Wow, what a lot of information. And that's why we value the partnership that we have between Michigan Farm Bureau and Varnum Law Firm. That was a tremendous amount of information that I think will be very helpful to the folks that tune in today. And I want to thank Craig Anderson as well for the additional insight on the Ag Labor Survey and why that's critically important. We do have a couple of minutes left if there are additional questions that anyone would like to put in the question and answer feature here in our Zoom meeting. If there are no further questions, we can wrap up a couple minutes early because that never hurts anything to get done early. But this information, as I stated, has been very helpful. Next week, in week 3, we will talk about where to find qualified labor. Varnum Law Firm will be back with us along with representatives of the Great Lakes Ag Labor Services to talk about their program and recruitment of H-2A workers. And we're excited about that program because, as we all know, finding qualified labor and a reliable labor source is a big challenge in our industry. So we've tried to put these series together such that we're providing a different look at labor-related issues every week. And then week 4, we will wrap up with question and answer session with a lot of the experts and try to include a couple of farmers in that program as well so that they can give firsthand their knowledge and insight into labor-related issues. So once again, we do have a couple of questions in the chat, and I'm going to go there now. excuse me. And someone asked if there will be a recording available. Yes, there will. And let me click the appropriate button here. We'll answer that live. Yes, there will be a recording of this program today. We will email it out to everyone who was on the session today so that you have a recording. We did the same thing with the program last week. Once we get it properly formatted, we will be sure to send that out. There was a question, and I maybe a statement, and Kim, maybe we'll throw this one out to you, but it says some of our H-2A employees are receiving stimulus checks. H-2A visa workers, not U.S. citizens. Any comment or statement that you'd like to share about that?
We saw this with the first round of stimulus checks too, and it's because they're just doing it based on Social Security numbers. So they don't have access. They're not cross-referencing the visa process to know who should and shouldn't get it, and it's not clear what anyone should do with that. There's not. So I don't think, from what we understand in the immigration rules, it should not impact their future immigration if they've received it. And I'm not sure that they would be able to effectively decline it and return it. So that's one of those still more answers to come. The other thing, quickly, as long as I have the floor. So this is the beauty of working at a big firm. I asked the person who's attending the National Council of Ag Employers about the H-2A refund for those H-2A FFCRA payments. And they are saying that they anticipate a new form in March. It's going to be a new 943. So you'll file an amended, but right now the form doesn't allow you to put those H-2A wages in. So look for something to come out in March.
Very good. Thank you for that. Well, Kim, Craig, thanks again for your great insight. Very much appreciated. To everyone that tuned in today, thank you for tuning in over your lunchtime. Hopefully you found today's program valuable and educational. We look forward to another great session next Thursday when we gather again over lunchtime. So again, thank you very much. Have a great week farming. Stay safe, everyone, and enjoy the winter blast that's about to hit us here over the next week. And we'll look forward to visiting with you next Thursday. Thanks for joining us.